Welcome back to our second session on AI and application of law. Our first speaker is Pałka from Jagiellonian University.
Nice.
And he is going to be talking about what's non-humanly possible, AI, laws, assumptions, and the case of privacy law. So the floor is yours.
Thank you very much, and thanks to the organizers. Thanks Bojan, thanks Miona, thanks everybody who contributed to organizing this event. It's really cool. I would ask at the very beginning for a favor. If somebody could take a photo of me with this slide, that would be highly appreciated, because this work is funded by National Science Center Poland, whom I would very much like to thank, both because I really appreciate their finding and because I'm contractually obliged to do so.
We will eliminate
also obliged to provide
We all are.
a photographic proof what I learned last year hard, and thank you very much. Now, to situate the talk I want to give you, watching this AI and law space, all the discourses under the AI and law label for the past decade, I think that 95% of the output could be put into one of the three spheres, right? Three discourses. First, there is the attempt to formalize legal reasoning / automate some legal tasks. In essence, try to have computers do what normally human lawyers do. The second discourse, that is somehow fresher because the previous one goes back to the 1970s, 80s. This is the past decades. Are the regulatory problems caused by the social adoption of AI? No? So now we have self-driving cars, automated weapons, Google ad delivery, etc. How should we regulate it? That's a policy question, and in some cases when people can do it, a political philosophy question. And the third prong, which somehow lately has become less popular than it used to be, are thought experiments based on the counterfactual that something like a strong / conscious artificial intelligence exists, right? And then philosophical questions: should we treat them as moral agents, moral patients? Should we grant them legal personhood? Should they be required to consent for sex? It really used to be a big debate. Now less popular, but basically the idea is, the question is, if we imagine the inexistent AI, what can imagining this and working through some problems tell us about implicit assumptions in our legal / philosophical concepts or theories? And what I think is kind of missing is the question to the effect of, how does the emergence of AI, used by people, not by lawyers to automate reasoning, but potentially used by people, challenge the assumptions law makes about the actual world, not in the sphere of risks to be regulated, but in the sphere of what's possible. This sounds vague, but I will try to show you on an example what I mean by that, and the example sort of touches upon the first discourse. So the plan for the talk is, first I will tell you about a paper I wrote with Giovanni Sartor's team this September called No More Trade-offs, GPT and Fully Informative Privacy Policies, which is an attempt to solve a particular problem of privacy law, and then use this paper as an illustration to the fourth type of question that I outlined before. So, for a second, getting outside of AI and into privacy law problem. The problem is with privacy policies. The documents that everybody clicks, they have read and accept, right? We know empirically that nobody reads them, yet these documents, in the internal logic of our privacy laws, both the notice and choice system in the US and the GDPR, play a very important role, right? Because both of the systems are based on an individual choice paradigm. The idea is that an individual should have access to information about how their data will be used, and then decide whether they want to use a service, they don't want to use a service, etc. Right? And interestingly, we do not currently live in a world in which it's possible to ask your phone, ask Siri or whatever, who will know I just ordered chicken tikka masala, and how will they use this knowledge? Why chicken tikka masala? That's an important type of food because it's the most strongly associated correlationally with liberal political views, right? We live in a world in which we can infer data about your race, your political views, your religion from seemingly harmful things like what type of food you order or what type of music you listen to. No? So it's an important thing. And yet we don't live in a world in which you can just ask your phone and get a straightforward answer. This company will know it and use it for this reason. This company will know it and use it for another reason. And the hypothesis here is that the reason behind this impossibility is not technical, no? The mere retrieval of information is already a trivial problem. The more complicated problem was the computer, the phone, actually understanding the command given to it in natural language, but this seems something we have solved to a large extent. And we hypothesize, having read hundreds of privacy policies for the purpose of tagging them for an old-school machine learning project, that this information that is necessary to answer a question like who will get access to this data about me is simply not contained in privacy policies. Privacy policies, this you kind of have to believe me, are written using phrases like we use your data to improve our services, not explaining what data and what does it mean to improve it. We share your data with our business partners. Again, they don't specify what data on who the business partners are. So these documents are largely meaningless. They don't contain information, and reading them is in effect irrational. Not reading them is a rational thing to do. And there are many reasons behind why privacy policies are written this way, but one of them is that the law requires privacy policies to be both comprehensive, that is, contain all the information about all the categories of data collected, all the purposes of processing, all the types of recipients, which is, if you are Google or Facebook or Twitter, really a lot of information. And the law also requires them to be comprehensible, explicitly written short, in simple language, easy to read for a human. No? When we assume that the reader is a human, in theory, holding these two requirements seems reasonable, right? Like we want all the information to be there and we want it to be easy to read, but because there is really a lot of information to represent, realizing both requirements simultaneously turns out to be impossible, right? That's why we end up with the worst possible world, which is the meaningless privacy policies. And so our idea was to drop the short and easy to read requirement, and so that's a policy idea for what should happen in privacy law. Right? We say drop the short and easy to read, make privacy policies fully comprehensive, make them contain all the information, and this would allow development of AI systems for question answering about data practices. And so what we did was we wrote a mock fully comprehensive privacy policy, and we wanted to see how good the existing consumer-oriented GPT 3.5 and 4 already are in answering these questions. So this is an example of how it looks like. You can't really see it very well, but that sort of is proving the point. We write a policy that every paragraph is one data type, no? So we say, we use your data in the following way. Email address, you provide us, we use it as a unique identifier based on contractual necessity. We share it with fraud detectors, who is a processor for the purpose of fraud prevention. You see, one paragraph is just one data type. There can be 50, 100, 150 data types. We end up with an unusable for a human policy that, however, contains all the information. And we want to see how good ChatGPT will be in processing this information. We ask it 6 questions. The first 3 relatively simple. What types of data does Orderu, this fake company we came up with, process about me? For what purposes it uses email address? Does it share? Who does it share geolocation with? Then 2 questions that need the GPT to process information from the entire mock policy, and the last question, which require a negative answer to be correct. We do it using, so Bojan mentioned the date, so let me also say we did it on September 29 to October 2nd, 2023 in Bologna, Italy. And we use short prompts, just asking the question, what data does Facebook use about me? And we get an answer that we then manually assess whether it's correct. We use long prompts, the same question, and then saying something like, in answering the question, please rely solely on the information included in the text, do not omit, do not summarize, etc., because those were the types of problems we expected. We again manually assess the answer. This gives us 4 settings, so short prompts, long prompts, ChatGPT 3.5, ChatGPT 4, and we ask each question 10 times using 2 different accounts, right? Because it turns out, I mean, the hypothesis was that it might not always give the same answer. So 10 is not, 100 or 1 million, but it's more than 1. And we also wanted to see if there is a visible difference between the accounts. And these are the results. Essentially, we noted whether it was a true positive, true negative, or whether it was a false positive, false negative, whether there was hallucination. This is a summary. Basically, as there were 10 runs, 10 signifies that a given setting got the answer right 100% of times, right? So if it's 10, it means that in every single run, it was the same. So you can see that the GPT-3 and GPT-4 got the simple questions correct every single time. There is an interesting phenomenon where one question was always correct in GPT-3, that's the question 3, whereas GPT-4 made some mistakes. That was a tricky question where it seems GPT-4 tried to infer a rule and apply it, and it turned out to be incorrect. Then, when it comes to merging information from throughout the document, question 3 and 5 was always correct. 4 was tricky. So, to discuss these results relatively briefly, we could get, they're really interesting, but they're interesting computer science perspective. It's not yet perfect, but it seems it's relatively close to getting there. That's, gets close to doing the job. One way to do this better would be to have the privacy policy even longer, because it turned out that if a question was contained within single paragraph, it always got it right. So we could not only structure policies by data type, but also by purpose, but also by recipients, etc. But then it would be very long, and that takes a lot of processing power, which OpenAI currently caps. So in short, it's not yet perfect, but it's possible. And that's the paper we wrote. And when it comes to a lesson for philosophy of law, what I would like to draw your attention to is that we live in a world in which some technically possible AI systems that could be useful for people, societies, etc., currently do not exist. And they do not exist because the data that would be necessary for their creation, like in this sense, fully comprehensive privacy policies, is not publicly available. And data is not available because the law assumes that the recipients of the data are humans with their own constraints, right? Like this short and simple language, concise privacy policies requirement that was inserted there to help humans prevents the creation of AI systems that could help them. So the question is, what tools could exist, right? If the law required meeting of information conditions for their development. That, can be possible in an unlimited number of areas, right? Information obligations in general, making market more efficient, etc. I guess you can imagine that. So to get back to the first slide on situating the talk, I think that was probably a wrong thing to say, that the move 4 doesn't exist. It's in a way a combination of all 4, with this important difference that the thought experiments, which I think are very useful, should not only play with counterfactuals on the AI that doesn't exist because it's not conscious or something, but on the counterfactuals on what kind of worlds we could live in if we required certain possibilities to be realized by the law, allowing automation of tasks. So, thank you very much for your attention. Happy to discuss, and thanks.
All right, thanks a lot. So, are there any questions? Yes.
Yeah, I'm the first one. So, thank you. It's immensely interesting, this thing for me. So, but let me I see the possibility of a paradox. So, for example, our human brains cannot compute the policies in this simplified form. I read a couple of policies myself in my life. I'm not proud of it, but yeah, for full disclosure, I know what they contain. So if we kind of adopt this approach for policies, and I can't think of other examples, but you might be able to think of some other examples. how will we make sure that they are humanly scrutable, basically? So if we complicate it, so if we make a hyper complicated, so the Facebook policy could have 200 pages now or more. So if we adopt this, it would have, I don't know how many pages of details about this. Then if we adopt this approach, we would have a policy that would be understandable by way of a machine, but we would also have a policy that's completely unscrutable to a human. And I don't know if there are any. I'm very interested in to hear this. If there are any fields, other fields in which we would have the same problem. Thanks.
Should I answer or do we collect questions?
I think we have time.
Okay, great. Thanks, Bojan. That's a great question. I think it's I don't think it's really as atypical in other areas of information processing as this might sound, right? So I think all of us sitting here hold some beliefs that we judge to be correct based on reports that are thousands of pages long. No, say sexual scandal in Catholic Church, right? They molested 300 people in Boston area. Global warming, no, the temperature seems to be rising faster than we can stop it before everything goes down. Those are based on reports that are 1,000 pages long. Somebody wrote them, and there is a human or two humans to read it and summarize it and write it in media, and on the assumption that this can be also checked by others, we somehow find these sources reliable. So the idea is not to make this not understandable to humans, because this is not understandable. It's fully understandable to a human who has the time and expertise to sit down and read it. But because people do not read these documents anyway, right? We're not really taking anything away from them. We still might have people to check it, but we suddenly make it possible for machines to make it not only, answer the questions people are interested in, but we take away the translation problem where, if you think about it, it is quite weird that we ask the company that is interested in presenting itself in the best possible light to engage in the summarization of the information it is a source of. But so I'm sure it can be a problem somewhere, but I also think not.
Domingo?
Yes, thank you. Great presentation. I just wanted to confirm a finding that I think you argued at the very end. So what you're saying is that your paper actually concludes that AI will be helpful in a way substituting humans in preparing decisions, legal decisions. Could we say that? Like I'm imagining something on the sorts of like probably one of the biggest nightmares of practitioners is I filed my case in court, and the day after I found out about a law that I didn't know it would be useful to the case. And my dream is that I have this IA that tells me every law that are relevant to my case, so I don't have to, because the legal system is infinite, or is in the example that you gave. It's out there. Of course, I could read it all, but it would be impossible. Is that it?
Let's say so, yes.
Okay.
Oh, that was the question. No, it's not that. I thought it was something you needed to make a larger point. No, it's not about legal decision. It could be about legal decisions.
Or interpretations.
No, it's about factual decisions. It's about, given my preferences regarding who can know my sexual identity, do I want to use this app or not? Right? Given my preference for living in an area that meets certain conditions, where should I even consider going for holidays this summer? Right? There are worlds in which AI can assist people with processing the overload of information that it does not yet do, because the information is not there, because we do not require it to be there, because we assume the cognitive limitations of humans that we no longer need to assume. That's the paradox, if you will, right? Like, we could have the systems if the information obligations were based on the assumption that they are for helping AI systems, but we don't have them to help humans, because to help humans we require the information to be short, so the information is not there. That's the intuition here.
Okay. No, but my question is, do you think we can extrapolate for what you did for privacy, for example, for privacy policies, we could extrapolate, for example, lawyers doing this in preparation for a case? That would be my question. Instead of helping someone decide, I'm going to order this food and I'll know exactly what information I'm giving and what they will do with it, I'm using this to prepare a case and I know exactly what statutes I have to read and the dominant interpretations in superior courts, for instance.
Probably, though, I would try to stay away from it, right? Like it's the no, because this is the complicated thing, right? Like the previous session was we saw where all the complexities stay there. So we're trying not to do the formalized automating legal tasks, but I'm sure in some way, sure, and in another it's complicated. Yeah.
You gave a rather kind interpretation why the policies are so terrible as they are. Companies faced with two contradictory demands. It also works for them, obviously, because that ensures that people are more likely to accept the thing. And I was just wondering, have you thought about it? That might be something for the future, about sort of adversarial attacks to what you describe. What would I have as a company to put in somewhere in this very, very long text, and that goes back to the first question, to make sure that whatever ChatGPT is telling me, it tells me, yeah, give that data away, perfectly safe, nothing can happen. Would that be possible to, put in these poisonous triggers that ensure that I get a company-friendly evaluation?
Thank you. I'm sure it would, but then it would not be good faith, and we would see it relatively quickly, no? I mean, so a really interesting question is, why are these policies not all reasons for GDPR violation cases against those companies, right? Because it's like in your face incompliant. It's in your face not meeting the requirements of Article 1314, and our intuition is, because it's impossible to meet these requirements, right? Like it's impossible to write a privacy policy that the GDPR currently requires you to write. That's why these documents are being tolerated. Now, you're right that the company has all incentive to present itself in the best possible light, so not to put that information there. But I think once it becomes automatically scrutinizable and the standard they have to meet is clear, because right now they can say, well, we tried doing our best, but we needed to make it concise. No, once the standard is just get all the information out there, once they put something like that, they get hit with a fine, and hopefully they stop, or I don't know. But yeah, it's always the possibilities for adversarial attacks. Very interesting thing to think about.
No more questions? Oh, yeah.
So at the beginning of this week, we had student conference, and I asked the same question there, so I'm kind of repeating it. So first will be about reading the terms of the service. As you said, no one is reading it. That's also kind of my impression. But then I found on the internet one US survey done with 2,000 adults in USA, and it says that around 39 of the percentage of people are sometimes reading it, and 20% most of the time are reading terms of the service. So I'm kind of just interested, is it just my impression that no one is reading? You mentioned some other surveys, so in which, yeah, maybe they're just really lying, or the sample was just really narrow. So do people really read terms of the service? And the second question, which is kind of maybe basic, so what's really problematic without collecting personal data on the internet? So, for example, if I'm searching for running sneakers on the web, for example, Decathlon, and then on my Instagram and Facebook starts appearing running shoes everywhere, I don't see any problem with seeing running sneakers all around my internet on my phone. So, what can really go wrong there? So, maybe it's a basic question, but I kind of need an explanation. Thank you.
Great, thanks so much. Two very good questions. When it comes to the no reading problem, terms of service is not exactly the same as privacy policies, right? Because the terms is the contract governing your relationship, whereas privacy policies is first and foremost information about how the company plans to proceed. So I wonder to what extent this empirical studies sort of can inform one another. I suppose they are the same. But when it comes to privacy policies, like, we really know people don't read them, right? Because as Bojan said, when it's a survey, they can lie. But there were a couple of experiments where people agreed to have, say, eye trackers for a month to just see what they look at, and nobody reads it. There is more. There are experiments when people are actually asked to read them and asked about how well they understand them. They misunderstand them, right? So empirically, it's established that people really do not, right? And even when they do, they misunderstand. Now, on what can go wrong, that is a great question. So the GDPR assumes that it doesn't matter. The GDPR is harm agnostic. It's about putting on a certain procedure. But we don't have to like the GDPR. I think from within the paradigm, the idea is that, right, so the paradigm assumes that you should have informational autonomy, meaning you should be in decision on who can use your data for what reasons, right? So the fact that you're buying sneakers and that will inform your ads sounds relatively harmless. But let's say I'm searching for whatever information that can be used to inform my religious convictions. I might be fine with, advertisers learning about it and showing ads based on it. I might be fine with Facebook algorithm choosing what to show me because this is interesting content, but I might not be fine about certain parts of the government learning about it, right? Or my future employer learning about it. So the idea is that you're at least supposed to have an option of controlling those choices, whereas the reality is you really can't, right? Because it is a black box that once an information gets out there, because it's being shared with business partners and other undisclosed recipients, you can't really know who will know what about you or how they will use this information. I agree, it's probably an overinflated problem with the privacy online. I mean, we're all using these things. If this was truly harmful, we would probably stop using them. There are no unwanted disclosures. And yet, at the same time, I have this intuition that there are some harms we can't really maybe foresee, and it's something we should at least try to shield ourselves from. But from within the paradigm, it's about control. No? You should have the information necessary for you to decide, which for now you do not.
All right.
Thank you.
So we move directly on to Domingo Farinho from the University of Lisbon, and he's going to be talking about AI and interpretation. What could go wrong?
Okay, say hi to everyone. Thank you again for the invitation, everyone. Bojan, Jodrak, Miona, everyone. It's been a great week until now. Let's try to keep it like that. Regarding the first slide, the usual caveats apply. Since I come from a very rich research center, I brought Pedro to take my photo, and Pedro brought me to take his photo. In the process, we also talk about legal theory and IA, but mostly we come for this. So thank you, Pedro. I'll be talking about IA interpretation, what can go wrong. I apologize for the fact that, unlike my Wednesday presentation, which was very well structured and based on a future paper, this is actually based on a memorandum I wrote to have a conversation, actually a meeting with a colleague from the Faculty of Engineering about a project we hope to present. So basically, on the downside, I plan to use you as guinea pigs for my ideas. On the upside, you can use me as a kicking bag for your comments. So I think we're more or less even. Okay, so some context to begin, then some basics on legal interpretation. I'll be fast on that section because everyone wants to have lunch. Then I'll go to theory of interpretation, case law in the AI, which is mainly where I raise the most questions I have and the most doubts. And then I'll just wrap up and refer to Pedro's presentation later. I did a slide on that, but I'm sorry. Okay, so context. I work mainly on the interconnection between legal theory and digital law. So I have been working up until like 2 years ago on GDPR. Then I moved on to the DSA. I'm actually finishing a paper which will be published next year in an Hungarian journal on the interconnection between GDPR and Digital Services Act. And now I'm doing work on the AI Act, which is an amazing law, as Boyan has been explaining to everyone during the week. So basically, this idea for the project I mentioned before came out of the evidence that, and now very detailed evidence, because the European Union is helping us confirm that, the idea that algorithms are already doing something akin to legal interpretation. And in a very practical day-to-day domain, which is content moderation on social networks. So basically, if you put on Twitter or on Facebook that you hate someone or that Minister X should die or something like that, and now unfortunately we have very good case studies with Israel-Hamas war, at least on X, you can know that, even if the process is not similar or akin to the process of interpretation, the output, so the result, is pretty much similar to what we call interpretation in a legal sense. So basically the idea come out to understand what we lawyers, especially legal theorists, could try to come up with if we talk to developers, to engineers. How could we try to figure out how could we make legal interpretation in the sense that algorithms do legal interpretation better and control the results, try to figure out what is happening when we say that algorithms are doing interpretation, are interpreting. So this is not, we're not going full throttle to predicting decisions. We are more modest on the idea that it would be already very good if we could give lawyers, judges, even, for example, companies that have to apply terms and conditions, a tool to understand how to best interpret the law. Of course, this doesn't solve what comes after, because then you still have application problems like balancing, redundancies, and the stuff like that. Pedro will be talking about one of those problems, which is analogy, and gaps. So I won't address that, but I'm addressing the problem of interpretation. This is, just to conclude the context, this is really interesting because according to the new transparency page of the DSA that you can check every day, there are now, at least there were this morning, 486 million moderating decisions since March the 11th. And from those 486 million decisions, 68 million were done by humans. So basically around 15%. So basically algorithms are the ones deciding if your speech is admissible, if the picture of your kids running naked in the beach is actually child pornography or just parental love and stuff like that. Okay, so let's move on. Okay, so some basics to understand what the questions I'm trying to pose. So algorithms classify uses of information. Just some data to accompany the slides. When they're in bold and italic, it means there's a problem I will be enhancing. So they come up with similar results. And the idea is when we're talking about interpretation in the sense of classifying information, humans do it, algorithms do it. What do we do regarding specific normative provisions, so legal texts? And the idea, this comes out of a paper published recently. There's a lot of papers on the topic, but I really enjoy that. And also they're my friends and colleagues. There's a paper by Pedro and David Duarte from last year that basically tries to show how normative texts regarding interpretation should be looked as speech acts. In this case, they are in written form. They come from a plurally composed normative authority without full content discretion. They're monological. They're addressed to indeterminate subjects, of course, continuous, and they are within a legal system. So this is what, both to humans and to algorithms, determines how you are going to interpret. And this is very different. For example, if we change anything in that list, instead of written form, you have oral form, for instance. Of course, interpretation is going to be different. The very famous case, if I say that you look bigger, you might think I'm calling you fat, but I'm actually saying that you look bigger because you're wearing high heels. So you can ask the person to clarify. You can't do that to the legislator. And I actually am going to show an example later on that even if the legislator would be capable of clarifying, he won't probably, or it might not want to clarify. I know this sounds weird, but at least in Portugal it happened. So after this setting, problems ensue. So that literature has, of course, been doing this for decades, trying to come up with a list of problems in interpretation. I just list a couple of them so that we know that I'm working in that setting. So ambiguity, of course, words comprise several meanings. That means several potential norms, because norms are meanings. Then imprecision or vagueness. Some examples taken from literature, legal and non-legal. Of course, the most famous example being that of game by Wittgenstein. So you can say chess is a game, football is a game, roulette is a game, and we as humans understand that we're talking about different things, but we can also understand that we're talking about the same concept, the same word, game. Machines probably will have to take some time doing that, although the recent level of difficulty, Masha will probably have something to do on that, say on that, will probably be able to comply with the idea of game that we now have. Up until some years ago, that wouldn't be easier for machines. Then you have the problem of degrees when you go to imprecision and vagueness. For example, rich, what does it mean? You can be more rich or less rich compared, attending to the point of reference. Arbitrary, for example, this is an example by Cario and Santiago Nino. You can add properties to the word arbitrary, so something that would be arbitrary on some property today might be arbitrary on some other property tomorrow, and that's, of course, something that we as humans tend to have some context to interpret. And finally, of course, the general problem of open texture, the idea that an object maybe you may add properties to the object later on. So an object very similar to other objects that you include in the word then come up with a different kind of property, and you don't know if you should classify it with that word. Another example, or a good example by Santiago Nin, would be a pen that instead of just writing whatever you want, when you write it in a language, it will actually make the text come out in another language. And should you call that still a pen if it now did this, which is not something that we usually correlate with a pen. What information can help you overcome these doubts and problems when we talk about IA? We know a little bit about it when you do interpretation by humans. Basically, the answer that literature has been giving you for years is that you need a theory of interpretation. So you need a way to go about these doubts. So you may look to intention, you may look to a lot of stuff. So let's consider that. So first thing, and this is something that is often implied but not explicitly said. When we talk about theories of interpretation, I think we should say that all theories imply that you are interpreting at least with the ability, the possibility of knowing the entire legal system. This is something like, for example, probably the most famous metaphor, the Judge Hercules of Dworkin. So, of course, probably won't be able to know the whole system, but there's the potentiality of it. It's available to you. You can try to access it. And theories of interpretation actually rely on this idea. So, for example, if you're intentionalist, you are trying to determine the intention of the legislator when he wrote a certain word, but you actually have to know, or you should be able to access that information all the times in which he has used that word, because that will be useful to understand his intention in that specific case. And the same thing for purposivism and even for textualism, in which you're trying to understand. And of course, there's originalism, but basically you can combine that with any one of those three. So that's not my most important point. So my claim, this is probably the only claim I'm going to bring to the discussion with the developers, is since you can look at theories of interpretation from a descriptive and a prescriptive point of view, doesn't the prescriptive point of view imply, when you look to algorithms, that you should use whatever criteria comes out of that theory of interpretation as the criteria to determine your data set? So, for example, if you are an intentionalist, basically that could mean that you are saying that the data set should be made other than the whole of the legal system. That's a problem I'll address later. Also, with everything that the machine can use to track intention. So, for example, preparatory words, interviews given by the author, the legislator of the normative authority, second-hand analysis. For example, people that did scientific work on the intention of the legislators, whatever you find that is acceptable to determine intention. And the same thing for example, contextualism. If you follow the Lebensform from Wittgenstein until now and everyone that has written about it, which is probably half of the humanity, you come out with the idea that you are, when you're doing textualism, you are relying on sociology, anthropology, behavioral psychology, in the sense that you are trying to find how a certain community uses a word. And of course, you can't understand that but just by giving them the legal system. You have to give them something else. And that, of course, is very complex, especially because textualism, as Pedro and David actually tried to show in their paper, is the most coherent, it seems to be the most coherent theory of interpretation. This is not my claim. I'm just using the claim by Pedro and David. So if you want to criticize it, wait for Pedro's intervention. So we can move on. So after this, another problem I'm trying to raise is, of course, if you look at what theories of interpretation can offer in the determination of the data set, of course, you have some problems. And two problems I already identified, I call them purism and collegiality. So purism is the assumption that you can actually rely on judges to only use one theory of interpretation. So there's this judge that comes out in the morning, he has this long list of processes, and says, yes, I'm an intentionalist. I'm going to solve everything today like an intentionalist, and that's it. And this is, of course, amazing. This would be very coherent even for to criticize and review these decisions, but that's not what happens usually. Maybe I want to be an intentionalist today. Maybe tomorrow I'm a textualist, because really what I'm deciding because I'm a Catholic. And so I use whatever I want to justify. It's the famous window dressing problem in judging. In judges. The other is, even if we could assume, and this of course could be done at least in a trial, in a laboratory way, that judges decide on they adhere to a specific and explicit theory of interpretation. Most decisions at the end of the day, even if they start in lower courts with just one judge, they end up in plural, in collegial courts. So, for example, the 9 in the Supreme, the 13 in the Portuguese Constitutional Court. And then you have a problem that you have aggregated series of interpretation, because maybe one judge adheres to contextualism, but the other adheres to intentionalism, and so on and so on. So we have a problem with using my claim, which is you should use theories of interpretation to build data sets to determine how the best way to interpret it is. So one question that then arises is, could we try to solve this problem by saying that then let's forget series of interpretation, let's use case law, because case law does the job for us. It's a form of getting aggregated, authoritative ways of interpreting. So the judges already chose, even if implicitly, their theory of interpretation, and they already adjudicated, or they are going to. So, but you know how they did in the past. Okay, so you could do that. What's the problem? Several problems arise depending on how you would fit the case law to courts. These are some of the points that I want to talk about with developers. I have at least one here, so if you can be generous enough, I can start doing that now. So one would be, we can fit the idea with all the case law in the courts in the legal system, and get the authorized version of the legal system, and then you could do interpretation with that. There's a very interesting paper, there's more on those, but I like this because the case that they use is interesting, called Generative Interpretation by Arbel and Hoffman from this year. And basically they took the very famous case of Hurricane Katrina, in which millions and millions of dollars in compensation would have to be decided solely based on this specific problem. Does the word flood in the American statute means flood by every cause, or human causes are not to be considered floods? And this is the discussion. And what motivates Arbel and Hoffman is that this actually $1 billion compensation was decided on dictionaries. So the judge in the appellate court said, I went to 4 dictionaries. This is the definition I got. I think this is how it should be interpreted. So we're going to consider flooding also as provoked by humans. And we don't know. I mean, dictionaries. I mean, do we rely on dictionaries for our common lives? So it's a problem they actually discuss, and it's interesting to know if they actually did generative interpretation, which basically they collected all the decisions regarding floods in the United States. They put it they fed it into the algorithm, and the algorithm came up with how it thinks that the word flood should be interpreted in liability cases. So another, okay, before I move on to the other, this could seem good to private companies and even to public administrations, but there's the problem of application. So even if you could sort it out through generative interpretation, then you would still have problems of balancing, of problems of empirical impossibility. So even if it's nice, it really doesn't promise anything else. And then there's also a point on 3 that I'll address this issue. So for companies, for non-adjudicating bodies, which is the point, this could help you know what to do with the meaning of the word flood, but then you don't know even if you use the correct algorithmic sense of the word, the rule, if the court won't say, okay, but for example, this interpretation is defeated, or this rule is defeated by a superior rule. So it also is problematic for courts, at least in my tradition in continental Europe, because it will probably cause what I call the conversion to an informal precedent system, which is if you now, for example, a lower court judge, have a system where you can ask the algorithm what the proper rule is regarding the meaning of the words and the sentences, and if you know that your superior court does not agree with that decision, that interpretation, wouldn't you feel like you should use probably not the AI, which probably you think it's more reasonable than the judges in the superior court, but to know that the judge in superior court can revoke your decision, so it's either you adhere or not adhere, but there's like an idea of precedent comes to mind. So that would be something we'd have to study. And another problem is, I actually had this problem here, and then I had breakfast with Masha by accident, and she confirmed that this is a problem. So we need to update, because of course judges will have new cases where they decide on the meaning of words. For example, they add a property to a word given some scientific discovery or some new sociological interpretation, and then you update the data set. But there's no, at least for what we know, that there's no guarantee that just by feeding the new data, it will behave in the sense that we want. So it will, for example, if you add another game as an example of a property of the word game, it will always know that that is a game. So that's a problem. And more on this on Pedro's presentation also. So if it's right, I came up with it. If it's wrong, Pedro will, of course, answer for it. Okay, so another hypothesis could you do something different? We could do what now is done in moderating algorithms in platforms. So they use everything. So of course you have trolls online. That's what the machine is feeding on. So of course there's going to be problems. And then Elkin Korn, in a recent paper called Contesting Algorithms, said, well, instead of trying to give to make companies use a different data set, so a better data set, let's put the algorithm of the companies talking to a public-owned algorithm, so sort of algorithm for good, so the good algorithm, and he would discuss with the algorithms in Facebook and X. So the idea of contexting algorithms is interesting because you could put two algorithms talking to each other, and what would happen? Let's see what happens. And this is something that has not yet been tested. It's really recent, at least to my knowledge, but it's interesting as a possibility. Of course, there's problems. It increases complexity, but because now you have two algorithms doing something akin to interpretation and combining and discussing. So this is a whole new level of trouble. And then you have, of course, procedural problems. If you think about content moderation, it's usually something done in minutes, seconds, days, it seems an eternity. And you would have to put one decision up to the other algorithm, wait for the decision. Of course, it's very fast, but it would have to be controlled. So that would be a problem. Last possibility that I will want to study, one could feed AI with the kind of concept that many scholars defend. Again, the reference would be Bulligin and Alchevron, which is the reconstructed legal system, which is, of course, legal theory's paradise. So you have this legal system, which is the norm, the texts, but this is all wrong because there's redundancies, antinomies. So let's do the right thing, and this is the real legal system, the reconstructed one, without any antinomies, without any redundancies, without any problems of interpretation. Ambiguity is gone.
Of course, this entails a problem. It can't be done. It's easy. It's very hard to think of this done to the whole of a legal system, even from a very small country. Maybe we could do it in like San Marino. I don't know. I don't know the legal regime, the legal order of San Marino, but okay. Is there an independent legal order? No. Okay. But so another problem would be that another thing that would be said, you could try to remedy this problem by doing and this is one of the things in my proposal for my project, is you could do this by what we call simulated sectorial domains. For example, instead of doing this, we could reconstruct the whole of urban planning law in Portugal. So this is the real urban planning law legal system in Portugal. We put some general legal principles in to simulate the rest of the legal system, and then we could probably do a data set of reconstructed legal systems, and this would be very interesting to know if we'd come up with better norms, in the sense that it would be something, because usually doctrine is very knowledgeable of case law and is also in tune. Well, it depends on the academia, but it's also in tune with what's happening in society, except if you're a legal theorist, of course. To conclude very fast, I think 1 minute. Okay, this is very fast. I'll be really fast. Just to conclude, this is a tribute to Boyan. In Portugal, we had this very interesting case. I'll skip the slides and I'll actually tell you the story, in which there was a law that says the president of a municipality can only be elected to 3 consecutive mandates. So, and I ask you to note that the law that is published on the official gazette says the president of a municipality can only be elected to consecutive mandates. But the text that was sent to the president to promulgation said the president of the municipality can only be elected to 3 consecutive mandates. So you can see the problem. If you read it in the version that is in the official journal, it seems that he can only be elected 3 times to the municipality where he is a president, and to any other of the 300 and something that are in Portugal. But if you read it in the version that was sent for promulgation, then you can't rerun for your own municipality, but you can go to the municipality next door and say, "Oh, I'm back." So, okay, that was the problem, and the problem was spotted. And I asked ChatGPT yesterday, how are we going to decide that? And I only told ChatGPT about the rule that I showed you, and he said it's pure textualism. There's the
ChatGPT is male. Yeah.
I don't know. I said, he said. That was bad of me. It said. They said. Okay, they said. I think is okay.
Gender and law officers.
So, okay, I'm sorry. So they said. It doesn't. Yeah. So they said, given the limited information, I would likely lean towards the literal interpretation of the provision, which means that an individual cannot be elected as president of any municipality. Okay, so and I think I would agree with that. When I remember when I thought of it the first time. So the president, the Portuguese Constitutional Court, given the fact that Parliament, just like 6 months after the problem was spotted, refused to interpret because the members of Parliament couldn't agree on what they had voted. So we won't make any laws clarifying send it to the Constitutional Court. So this is amazing. It's my favorite part of the story. So it went to the Constitutional Court, and the Constitutional Court actually took the decision combining 3 conflicting principles. And if you are a legally trained lawyer, you go and you think, okay, they chose these 3, they're not stupid, but I could add a 4th one and no one would say anything. They probably just, okay, this is good, you remember a 4th one. And maybe if I took one out and put another, which is not completely equal, it would still be good. So basically the Constitutional Court just chose the 3 that he thought they were best, so he made a choice. And he actually came with the consequence that the rule that came out of the decision of the Constitutional Court was the version that was sent to promulgation, but not the version that is in the text on the official gazette. And the reason is very simple, and this is important. The reason is, if we read it as it should be read, and the court admits that means that you can never again be re-elected. And there's a provision in the Constitution, it's not the only one, the only thing they wait, that says you have the right to be elected. So this would be an awful restriction. So in the balancing, we should not restrict it that much, even if the text doesn't say that. So I take pity of ChatGPT and I tell ChatGPT, look, there's this provision that I didn't tell you that the system has that says people have the right to be elected as president of municipalities. And after 3 times pressing him to answer, and this is true, I was pressing him, said, oh, you should take this into account. But what is the decision? If you were just, oh, you should do that. So after 3 times, he then says, I actually basically maintained my decision. So it maintained the decision, very textual, very contextual, saying he still can't be re-elected to any municipality, which is the opposite of what the Portuguese Constitutional Court has decided. Does this comes with a lesson to finish? What does this tell us? Well, the questions are, does this confirm the idea that there's a preference for case law or reconstructed data sets? That is, if we go in the idea that the original claim that you should go, you should build a data set on a certain specific normative theory of prescriptive theory of interpretation, probably you will get problems, as the decision by ChatGPT against the decision of the Constitutional Court says, because it's easier for judges to pick criteria to interpret whenever they have to come up with hard cases, even in easy cases. So I just want to say that although this is very problematic, what Pedro and anyone talking about application after interpretation is even worse, but I call this the optimistic note, because why not? And I thank you. I think I took too much time. Thank you very much for your attention.
Thank you very much. All right, so in the interest of being fast, then we shall collect questions all together. No questions?
Yeah.
The table is, the panel is questions.
No, just a very brief question. So you were mentioning at some point, for example, Altrona Buligin. Mm-hmm. They have a specific theory of interpretation in mind. So maybe my first question would be, what is your theory of interpretation to base all your findings? Okay. And the second one is, when you arrive to the idea that there is a contradiction, that there is a gap or whatever, do you think that we are still in the interpretation thing? Or we are just past the interpretation stage, like the identification of the norms, and then we are having problems of systematization? And then we take some specific stand on those problems that then, according to your theory of interpretation, naturally can conduce you to reinterpret, for example, the legal texts in a way in which they eliminate, for example, these problems, or I would like to hear more about that. Thank you.
Okay, thank you.
Does the Constitutional Court of Portugal actually maintain more or less a strict doctrine of legal interpretation, like textualism or intentionalism? Because, for example, the Serbian Constitutional Court doesn't do it, but ChatGPT does. So kind of if I compare ChatGPT with the Serbian Constitutional Court and like had to vote, would you rather have chatbot as the Constitutional Court or the Constitutional Court? I would be torn.
Probably, but you would be torn.
And I would probably lean towards Team Robots.
Pedro?
Surprising.
Quickly, and I won't mention all the things that you said about me. The problem is that we, in the Portuguese legal system, we basically follow, well, not all of us, but the Constitutional Court basically follows Savigny, and everything can, jump into getting the right meaning, whatever that is, of the provision. So to have an AI system predicting the Constitutional Court's decision would entail, encoding all the different theories of interpretation, and at the same time encoding some sort of algorithm that would balance them off, because the justifications sometimes are like outrageous. They just say, because it's so clear that textualism shall prevail over purpose, or the purpose is so important that it shall prevail over anything goes. So that's basically a comment of a problem of theories of interpretation, not a problem of artificial intelligence.
And I think last question, Shema.
Masha's also.
Oh.
Mine, I mean, I have an essay written, so we can have lunch later. But one thing I wanted to mention, you really compare it to the moderation on social media, and I think the problem there is that sort of how these algorithms are built is that so for social media to over moderate is often better than to under moderate, right? So this is where like what the precision there is and what the cost of error is are very different in these kind of scenarios. So I don't know if this example is a good one in that sense that it would be a very different model actually that you would really want to Twitter suppresses a lot more things probably than it should, because sometimes it's a question not for Twitter is not how it should be interpreted, but how it could be interpreted, right? So if there's more interpretation that even a person meant, if it offends someone, that we should moderate it, right? And this is not a situation here. But in general, I think that it's opposed to what I've talked earlier. The data is very important, but I think there's much more caveats to it than just deciding which data you should feed the machine. And depending also on what you want to do later, that also might inform you what data you want to have. It's one of the steps, and it's one of the early steps, but it's not necessarily the first one. I think in this scenario.
One last remark from me. This is good place to suggest another possible solution, which is you should just stop using articles. Slavic languages have no articles and work fine. These are useless words, only cause problems. Thank you.
I'll start answering from the end. I agree with you. Okay, so starting with Giulietta, I'm very much in. If I have to pick my own theory of interpretation, I'm very much pro textualism, and I rely heavily, for example, in Pedro's and David's article to show why it's a matter of coherence. It's, although it sometimes seems harder because it's easier to show intention most of the time. For example, I think it's in a sense more descriptive of what the reality is when you use natural language, even in the legal domain. So that's it. As for the interpretation application divide, well, I do believe that divide exists. I ended up just showing that I think we should actually use that divide analytically. So we should look at problems of interpretation, because it's actually a moment where you can choose if you go on with the algorithm or you stop the algorithm. Maybe you just want to use IA to come up with the word, and then a human will do the process of balancing and the process of analogy. And that's why I said Pedro was going to develop that. Or you may want to go on and then say, no, now we have the interpretation done by IA, but now IA will continue on and it will solve the problems of gaps and it will solve the problems. I'm not going into that because I think we should do baby steps. So let's center our interpretation in my case for now. So that I would say that. Then the problem, Boyan faced the problem that what is the best data set, the question of ChatGPT versus the Constitutional Court. And I think Pedro's comment goes in the sense that I would go, of course, I know that we have to accept that life is very existentialist and we're all going to die. But in the meantime, maybe if we can bring some assurance and safety and to decisions, I would like that. And I think I would also side on the side of robot. I would like to have some sort of way to predict how the Constitutional Court in my country is going to interpret, because I think everyone would benefit from that. So that would be my comment. And Tomasha, I think you're right. I mean, I understand what you're saying about content moderation as being a specific case. Actually, what motivated me was a specific provision that's in the very beginning of my presentation. I think it will change slightly what you said. We don't know because it's going only in effect in February the 17th. Where is it? It's here, which is Article 14.4 of the Digital Services Act. That actually it's like an atomic bomb by the EU that says from now on in Europe all terms and conditions have to comply with the Charter. So basically, the question of course, you can say this is even going to increase the problem because they're going over blocking everything and they're going to but at the same time it's going to put regulatory agencies and courts actually doing interpretation on terms and conditions regarding the charter, and that will change everything because the charter, as you very well know, has its own case law, so it will change the way that up until now moderation was being done. It will have to. I don't know how. That's why I want to start studying it right now. But if we take the Article 14.4 seriously, basically terms and conditions have to comply. So, for example, if you have, and you do have a rule in Meta and Facebook saying we will take down every hate speech, you have to know if hate speech, what predicates hate speech in the terms and conditions of Meta, it's the same thing that predicates hate speech in the case law of the European Court of Human Rights. And this will be interesting. That's the sense. So thank you very much.
Thank you, Domingo. So we will finish this session here, leaving Julieta's and my presentation for the next session, so that we can
Eat something.
eat something. Then after that,
Yes.
we continue with the work. So let us please do it in half an hour, maybe, so we save some time because we're 1 hour late. I think we're pushing some records here. So in half an hour, see you here.
Thanks.